Aziz Huq is a scholar of the U.S. and comparative constitutional law, and he talks about democratic backsliding. It is a boon crop for that, as is his expertise in the regulation of AI. This is pretty good. He picked a few areas of law that are unlike, say, buggy whip regulation. He's really on exactly where we are as a society. And he has a new book called The Collapse of Constitutional Remedies, which we are going to get into. I've been reading Aziz for quite a while. University of Chicago professor, former law clerk for Ruth Bader Ginsburg. Welcome to The Gist.
Hey, Michael. Thanks for having me.
Absolutely. Is collapse, because I read the book and I took it to mean that these are warnings and these are developments that we should be concerned with. But why is it a collapse, as illustrated by a building that has been all but razed on the cover of the book?
Yeah, I can lift up the book so people, if they're watching, can look at it. I think it helps to start by saying what's collapsed and locating people. So I think the central topic of the book is, what do federal courts do in terms of providing remedies when people's constitutional rights are violated? Now, that's actually got a bunch of moving parts in that question, and the moving parts need to be clarified before we can answer the question. So one piece of it is, well, what are the federal courts? Well, we have both state courts. So I live in Illinois, and there's a bunch of courts that are created by the state of Illinois. And we have federal courts. Federal courts are associated with the national government. They've existed since the early 1790s, and in part they're written into our Constitution. And then what are constitutional remedies? Or what does it mean to remedy our constitutional rights? Well, we all know that we have a slate of rights that are identified largely in the amendments to the U.S. Constitution. For example, the First Amendment starts, Congress shall pass no law protecting the rights of free speech, free expression, association, and the right of free exercise of religion. We go on from there, right? But one of the striking things about the Constitution is that it although it sets out rights, it doesn't say how those rights are going to be vindicated. It doesn't say how an abstract idea that I have an entitlement under law is made into something real. Right. And particularly over the 20th century, what's emerged is a toolkit on the part of our federal courts for vindicating rights. And the toolkit has a bunch of pieces in it. And the core point of the book is to say, look, that toolkit, which was built up largely in the 50s and 60s, has over the last 30 or 40 years been unraveled. Courts have taken out pieces of the toolkit. It's not all of it is gone, but a whole bunch of things that were previously available, a whole bunch of tools that people could use to vindicate their rights in court that were available, have been negated or eliminated by courts. And so when I describe, or when I use the word collapse, what I'm describing is a process, not an end state. And it's a process which I think is a disappointing process, where once we could turn to our federal courts and find a robust set of options for vindicating one of the various constitutional rights we have. And today we have a much more limited toolkit for doing that.
Was there a limiting principle on what rights we would have for redress? Another way of asking this is, were there any rights that were given that you question that maybe it is proper that they've been pulled back? Or avenues for redress, I should say.
I certainly have views about how to read, for example, the Constitution's First Amendment, the free speech clause. I certainly have views about the Second Amendment, about the Fourth Amendment's promise of protection from unreasonable searches and seizures. There are absolutely some decisions of the Supreme Court saying this is an application of one of those rights that I think is right or wrong. And I think that's true for everybody, right? Everyone has views about, look, the First Amendment should cover, let's say, there was recently a case about access to pornographic sites under a law in Texas, right? And there are some people who feel really strongly that the First Amendment should cover obscene speech. And there are some people who feel really strongly that the First Amendment should not cover speech that's pornographic. I can't give a blanket answer to your question, because I think that in thinking about any given right, you've got to think about, do I think that this application of this right, say to pornography, say to campaign finance, say to anti or pro-abortion speech that's occurring near an abortion clinic, you got to think about each of those applications and whether you think they're right or wrong. So absolutely, I don't think that the Supreme Court has gotten every decision drawing the metes and bounds of constitutional rights correct. I think that in some instances it's gone too far, in some instances it hasn't gone far enough. But I cannot imagine anyone who thinks that the Supreme Court has always got it right.
No.
Right? Everyone thinks that some rights have been extended too far. Everyone thinks that some rights have not been extended too far. Right? We just differ on which they are. But that's a separate question from the one that I'm interested in. The one that I'm interested in the book is, okay, the Constitution says a bunch of stuff about rights, and we all know that stuff. But what does it say about how those rights are made real? Turns out that it doesn't say very much at all. There's one provision that actually speaks to right. There's a provision called the suspension clause, which is in Article 1 of the Constitution, which talks about something called habeas corpus. And we can talk about what habeas corpus is. But that's pretty much the only provision in the Constitution that talks about how do rights get made real. And as a consequence of that gap, it has been courts' responsibility, or it's been the responsibility that courts have taken upon themselves to define when and how rights are vindicated and when they are turned away. And so one of the things I try and do in the book is to offer the reader illustrations of cases where I think for most people, there's clearly been a constitutional right violated, and where a litigant is turned away. So, for example, I give the case of a man called Alexander Baxter, who's attacked by police dogs, mauled by these dogs, and is told, well, there's no remedy here, and there's a kind of technical reason called qualified immunity for why there's no remedy. But the fact is that 50 or 60 years ago, had he brought the same case, he probably would have gotten some kind of a remedy for his right. And today he does not. And that's the gap that I'm trying to capture with the word collapse. Yeah.
And this was one of your earliest examples, and another one was a chicanerous firm that advised on paying state debt, I think, and their defense wasn't something like, no, we didn't lie. Their defense was something like, this federal agency should not exist. Tell me about that one.
Yeah, that's right. So I just played out the main strand in the book, which is the idea that there's a bunch of rights that we have that we have on paper, but we don't have in practice because the courts have withdrawn remedies. That's not true across the board. As the Supreme Court has become more closely aligned with the project of deregulation, the court has been more and more willing to hear challenges to particularly government regulatory agencies. So things like the Department of, in that case, it was the Consumer Finance Protection Bureau. But there are important cases involving the environmental law and the like.
Right.
And across those cases, the court allows the constitutional challenge to proceed. And here's the case on the merits. Even though the kind of harm being experienced by the person claiming the constitutional violation is pretty abstract and pretty unconnected from the actual facts of the case. So what do I mean by that? So in the example that you pointed to, Mike, which is a case involving a California law firm called Cellular Law. Cellular Law was advising, I think it was homeowners, and giving what I think is fair to describe as misleading or seriously incomplete financial advice in ways that allowed it to make profits and that left the people who it was advising out in the cold. And the Consumer Finance Protection Bureau starts an investigation and says, give us documents. We have the power to subpoena you. Cellular Law challenges the subpoenas on the ground that the Bureau is improperly constituted under the Constitution. That it's that, and there's a kind of technical theory about why that's the case that we can just ignore for the time being. But its complaint is not, hey, by subpoenaing me, you're infringing upon a certain kind of personal right. The complaint is, hey, the director. The complaint is, in some sense, hey, there might be a case in which the president disagrees with what the director of the bureau is doing, and might want to fire the person, but won't be able to as a matter of how the statutes are written. And you, the Supreme Court, should intervene and protect us now from this subpoena, because in this hypothetical future state of the world, maybe there's this tension between the president and the director, and it has a constitutional dimension. So that far in the future hypothetical problem is recognized in the Cellular Law case as the basis for hearing and deciding the case on the merits. Whereas in the cases involving, it's most often victims of police violence.
Yeah, guy attacked by a dog.
Yeah, the guy attacked by the dog. Baxter is, I think, the really sort of graphic and very powerful, for me, example of that. He's a homeless guy. In the cases involving kind of the ordinary people, the court, even when confronted with not an injury that might happen in the future, but an injury that's happened in the past and that's left profound physical harm to the person. In that case, the court bats the litigation away, but opens the door to essentially the regulated entity, the corporate entity that's challenging the regulation. And I'm going to give you an imperfect distinction here, and I want to recognize up front that it's imperfect. But I think you could say very, very roughly that in the cases where the court has limited the availability of remedies, usually the person claiming the remedy is an individual. And usually what they're doing is they're concerned or they're protesting about the way in which the coercive, the violent powers of the state have been used. Mm-hmm. And very, very roughly, as in the Cellular Law case, in the cases where the court's been much more open about when and how it will hear a case, generally, not always, generally, the litigant has been a corporate entity, a business, and what it's doing is challenging a regulation. Mm-hmm. And so you have two very different legal regimes for different kinds of actors in society. Right. And I think that whatever way you want to level up or level down, I think that the gap itself is a matter of concern.
Right. So you're saying the Supreme Court is bending over backwards to find reason to look at regulation, government regulation, and strike down regulation, but they're turning a blind eye to specific government actions, especially when it comes to policing, excessive policing, the individual. They're doing exactly the opposite and not finding the remedies for these things.
And I want to emphasize, or just build upon what you just said by emphasizing that, we can disagree about what rights there are, right? This is actually not a question of what Fourth Amendment rights you have against the police, or what rights you have against certain kinds of government regulation. This is a question of who gets into court to have their day in court. And the distinction I'm drawing is between the person who is told you cannot even get past the first stage of litigation, which is called a motion to dismiss. You cannot get what follows that, which is called discovery, let alone a hearing in court, as opposed to the person who is able to get not just the courthouse door open, but get a hearing and then relief on the merits, right? So it's not a question of what the rights you have, it's a question of who gets into the courthouse door or who doesn't get into the courthouse door.
Mm-hmm. There have been a bunch of Supreme Court cases recently where, I guess you could say, perhaps overly simplistically, the police lost, right? Barnes versus Felix, and sometimes victims of the police win. Are those exceptions, or do those still fit in with your thesis?
There are certainly instances in which either police or prosecutors go so far that even the Supreme Court, as currently composed, feels the need to rein them in. Here I think the most interesting cases, which I think are actually about prosecutors rather than police, and involve a process which happens at the beginning of a criminal trial called voir dire. Voir dire is if you've ever served on a jury or if you've ever been called to jury service, right, there's this moment where you get brought into the courtroom at the beginning of, they're trying to figure out who's going to sit on the jury. And you get asked a bunch of questions. And the questions are about, are you going to be fair, or are you going to be unfair? Or are you going to be biased? And through asking questions, the prosecution and the defense will pick a jury. And that happens in criminal cases, that happens in civil cases. So there's a bunch of cases, or there's a principle that applies under the Equal Protection Clause, that if you're a prosecutor, actually if you're a defense attorney too, but these cases involve prosecutors. If you're a prosecutor, you can't use race as the basis to pick the jury. You can't just be like, okay, let me look down the list and let me find all the people who are African American and let me just strike those, right? So that's a general principle of law. Everybody accepts that it's good law. But of course, it matters how the principle gets implemented. It matters whether the criminal defense, the criminal defendant can turn around and say, hey, prosecutor, you've got to give me your papers and you've got to let me see how you decided to pick people or kick people off the jury. And the court's been very, very reluctant to give defendants.
Right. So this is one of the court gives you a right, but doesn't actually have any mechanism to enforce this right. Is what
it's limited the ability of defendants to discover what's in the prosecutor's papers. But then this series of case comes along that fits your pattern. And it's a series of cases in which the prosecutor does, and the best example is that in one case called Foster v. Chapman, what the prosecutor does is essentially he has a list of all the potential jury members and he writes B beside the black ones and W beside the white ones. Yeah. And it's just, he's not even hiding it, right? It's just so obvious. And then he strikes all the black ones and he doesn't strike the white ones.
What was he saying? It meant bad and wonderful?
Maybe, but it turns out that bad also, bad,
just so happened. There's a strong correlation. Yeah.
So and in that case, the court is, essentially says, oh, come on, this, you can't do it this overtly. So Foster v. Chapman, as like the policing cases that you described, is a case in which, the court finds in favor of the criminal defendant. There are some instances in which an agent of the state goes so far.
Right.
Even this court will say, no. But that's still, in the mine run of cases, in most cases, the general rules of immunity and the burdens of proof that are imposed, particularly on individuals who are subject to state coercion, are going to shut out remedies.
Okay, so take that and now apply it to the government regulation cases. How does the court make sure it's not just a fig leaf, unlike the police or prosecutorial cases? How do they give those remedies teeth?
Yeah, what do you mean by fig leaf?
Well, I think you were saying that in the prosecutorial cases, the court has given a fig leaf right. And as long as the prosecutors have de minimis wiggling around the fig leaf or subverting the fig leaf, they know how to get around it. Yeah. But you're saying it's not true with real regulation or with something like the EPA or the Consumer Finance Protection Board.
So in challenges to regulation, I think two things have happened, only one of which I write about in the book. The thing that I write about in the book is that the court, in cases like cellular law, has been very willing to allow a challenge to regulation to proceed, even if there is no concrete or observable harm to the regulated party as a consequence of the alleged constitutional violation. Right? There's a gap, that is, between the theory of constitutional harm and the situation of the litigant, right? And I gave the example of cellular law, where the challenge was, hey, the president doesn't have enough power to remove the director of the CFPB. But you're like, wait, but the president's never tried to remove the director of the CFPB. Why is this a problem? Why isn't it something that can that would only emerge in the future? And there's versions of that for different constitutional challenges, right? That's what I'm writing about, which is the availability of remedies. A second thing has happened. The second thing that's happened is that, particularly over the last 4 or 5 years, which is actually after I wrote the book, the book's from a few years ago. And
that's interesting. That's why a couple of recent cases came to mind that I thought contradicted it in some ways. But go ahead.
Yeah, it's a 2021 book. Yep. So one of the things that's happened in the last few years is the court has become much more aggressive about striking down regulation. And maybe some of, this is, I think, we're now in the weeds of technical legal doctrine. But for what it's worth, last year, the court issued a really practically important opinion that gives it a great deal more power than it historically has had to invalidate regulations that are issued by a federal regulatory agency, right? So you have a willingness to hear cases that's increased, and at the same time, a willingness to strike down regulation that's also increased. Can I say something else about what's happened in the last few years? And I think it goes to sort of the cases that you're talking about.
Go ahead.
So, I finished the book in 2020. While that summer at the beginning of the pandemic that we all try and forget was unrolling, right? So I probably have a blank spot where in the moment in time at which this book was being written, because like everybody else, like I found the pandemic so traumatic. Mm-hmm. But remember, that was the summer of the big Black Lives Matter protests.
Of course.
And so I finished this before those protests had actually completely unspooled. Mm-hmm. And there was a really interesting moment in, I think it was 2000, 2001, almost in 2002, where there was kind of a consensus that, hey, we need to do something more about police violence. And part of that consensus became pressure on the Supreme Court to roll back some of these doctrines. And you had a series of both liberal and conservative legal scholars saying, hey, you, the Supreme Court, have gone too far. You need to pull back on some of these limits on remedies for people who are victims of police violence and the like. There was a lot of focus on a doctrine called qualified immunity. And then there was this kind of bubbling set of cases where the court almost looked like it was going to scale back qualified immunity. It decided for a couple of people who were victims of police violence. But it didn't, at the end of the day, change the rule. It didn't, in the end of the day, change the law of qualified immunity. So absolutely, there was this moment of sort of what looked like it could be change, but it doesn't cash out into something durable.
Right. And so that would, of course, only be on the federal level. And the states had the ability to do that, too. And very few did. I think New Mexico did, and maybe Colorado did with an asterisk. Maryland, too. Do you think that a change in the qualified immunity rules, maybe this gets beyond your ken as a scholar, but would truly change policing? I have my suspicions.
I think that the case for giving people damages when they are badly hurt by police does not rest upon, what the economists would call a theory of deterrence. The reason that you give people damages when they're really badly hurt by the police is not you think, well, the police will do something better next time. It's that people who are badly hurt by agents of the state have a moral claim.
Yes.
Yeah, they deserve restitution. They deserve some sort of payment.
Right. But to be clear, so our listeners understand, the victims still get what they deserve, but it's paid out by entities other than the exact police officers. That goes to the qualified immunity question.
Let me explain why, even if you got rid of qualified immunity, you actually wouldn't necessarily see that much change in policing. In Chicago, where I live, the city of Chicago has a separate judgment fund to pay out to victims of police brutality. Chicago has a long history of police violence. There was a particular unit, for example, through the 1970s that engaged in what I think now is correctly characterized as torture of a series of different people. And in part because of the damages claims brought by those torture victims, the city set up this judgment fund. The judgment fund does not sit in the police department. It sits on the books of the city. And so every time a claim is made on the judgment fund, the city's assets get drawn down, but the police department's budget doesn't change. And because the police department's budget doesn't change, there's no pressure on the police department to change its conduct, right? So in Chicago, at least, yeah, you could give people more remedies. You could do away with qualified immunity. You could do away with other doctrines that the court has fashioned to limit remedies. And it probably wouldn't change policing that much. Maybe there would be a kind of public effect of, gosh, there are these big judgments. Isn't that embarrassing? But that's a very indirect effect.
Yeah, and the actual judgments from the police, the individuals would probably be subsidized by unions, and then they could declare bankruptcy, and this would be but a small fraction of what state entities, even if you don't have these funds. New York City pays out hundreds of millions in claims, not just for police brutality. But I agree with you. I don't think it would affect much, and maybe there's an argument for some form of justice, but if what we're after is fewer people who are victims of aggressive policing, I don't think that's the right way to get there.
Yeah, let me push back on the argument that I just made.
Yeah,
let me give you the other side of the argument, right?
Yeah.
So hopefully, your listeners want to hear all sides of what's a complex issue, right?
They say they do. I don't know if the listening statistics.
If you don't want to, just tune out for the next 3 minutes. Tune out. So if you go outside the big cities, and you look at policing at the county level in small cities across the United States, right? Those places do not have their own judgment fund. So what are they doing? They're buying insurance. They're often working together. So you'll have a bunch of counties working together or a bunch of small cities working together. They'll get an insurance pool, and the insurance is being provided to that pool of counties or cities by a commercial insurer, by an Aetna, or by some other body that does insurance, right? You and I have car insurance, right? We have home insurance, What have you. Okay, so if you've got car insurance, let's use car insurance as an example, right? So I have State Farm, and State Farm, it has me put in a device into my car in order so they can alert me, hey, Huq, you're braking too fast too often, stuff like this, right? They want to find a way to give me feedback in order to minimize my risk of getting into an accident, right? And we're familiar with, insurers wanting you to buy a lock for your car or other things that do the same thing. So it turns out that happens with insurers of police departments too. Insurers of police departments will respond to the fact of having settlements or having judgments against the police departments by studying what the law is, studying who is winning, and saying, hey, police departments, you ought to do these kinds of trainings, or you ought to install these kinds of policies in order to minimize the kinds of claims that are going to get to judgment, right? And so while it's true, I think, that for the big cities, right, Chicago, New York, LA, because they're self-insured, because they have their own judgment funds, there's not this feedback mechanism. But for smaller cities, just like you and I, when we have our driver's caps on, right, we're actually getting a little bit of feedback from our insurers, right? And that one of the really interesting things about technology is that technology is making that feedback super fine-grained, right? You know, the thing that's in my car now will tell me, hey, exactly, this is how many times you've hit the brakes too fast. This is how many times you were going, 45 in a 40-mile-an-hour zone or what have you, right? And here's where you need to slow down. Here's what you need to do, and you need to change, right? Technology is allowing much more fine-grained feedback. And maybe that could happen in the policing context too. But of course, it only happens in the shadow of tort judgments.
Right. On the other hand, the big cities will give these judgments without too much of a fight. And if your municipal life and funding, not just the police department, but the schools, depends on you not losing a lawsuit, smaller cities will much more aggressively litigate lawsuits against them. So that might not be good for the victim.
Not quite, because what happens when you get insurance, this happens in car insurance too, auto insurance, right? One of the things you give up when the small city buys insurance, the small city gives up its right to litigate the case. It hands over that right to the insurer. And absolutely, there are instances in which the insurer will say, we want to litigate. But in most instances, the insurer will say, we want to settle, right? Because the insurer just doesn't want the law on the books that may be bad law for it in a later case. So it's controlling the cases that are going to trial or not going to trial for small cities. That's not true, again, really clear, not true for Chicago, not true for New York, LA, other big cities.
Have you looked at how it's affected actual policing? I've tried to. I have to rely on just the popular press reporting it in places like Colorado and New Mexico that pass versions of it.
The past versions of the qualified
immunity, yeah.
I'm not aware of anyone who has looked at that. And my reading of the literature, I think and maybe it's somebody you've had on your show, but the person who I think has done a really great job of this is Joanna Schwartz, who is a professor at UCLA, who has a terrific book that came out, I think, a year or so ago. And her academic work suggests that the way that people, or what matters in terms of whether people get a remedy in a particular place with respect to policing, turns not just upon the law, turns not just upon whether there's qualified immunity, but turns upon things like, well, are there lawyers who you can find in a city who are willing to take these cases, right? And so what she looks at a bunch of different cities and points out, hey, there are some cities in which there's a bunch of lawyers who will bring those cases. I vaguely recall that Philadelphia is one of those places, right? And there are a bunch of cities where there are just not lawyers. I think she talks about Dallas-Fort Worth, right? There, for whatever reason, that group of lawyers has never emerged. And so, again, I hate to give the it's complex answer, but it's like anything that's embedded in a complex web of our society, where there's like a whole bunch of moving parts that are at work. And Joanna's work suggests you got to look at all the moving parts to figure out how much difference a qualified immunity change will make. Yeah,
I've read about her work. I should have her on the show. One other case I want to ask about policing, which was Barnes versus Felix. You're familiar with it? I'll summarize it. The Supreme Court. Yeah, the Supreme Court. This was a case, and it was a 9-0 decision. And the Supreme Court essentially clarified when police use force, shoot a victim, should they be taking into account something called the totality of circumstances, or should it just be right there in the moment of threat? And even though the Supreme Court had in the past said, no, it's the totality of circumstances, some circuit courts were still using a moment of threat doctrine, which really lets the police off with anything, right? The police, all they have to say is, right in that moment, I concluded that I was in danger, and they would always get off. And this was a 9-0 decision. As I understood it, it was somewhat shameful that some circuit courts were allowed to still use the moment of threat test. So how does that fit in with the overall thesis?
I think it's in tension with the overall thesis. It's an opinion that comes out later than I can always say, oh, it comes after the book, and therefore I'm not responsible.
No, it came out just a couple months ago. Yeah.
Yeah, but absolutely, I don't want to. I think I'm in the book. What I'm trying to do is to paint a general picture, and say, hey, this is the overall movement of these cases, and I think I have that right. But absolutely,
I think you're definitely right on the regulation side of it. Yeah. I just see a little more noise on the policing side.
I think I agree there's a little bit more noise. I think one of the reasons that Barnes is interesting, and I can't quite figure it out, is that Barnes is the kind of case that I would have expected in 2021 or 22, where there was a little bit more kind of public discomfort about police violence. And, I don't read opinion polls, but my kind of general sense is that discomfort about police violence has receded between 21 and today. And it's interesting that Barnes comes out today, not 3 or 4 years ago. I don't quite know how to explain it. If I had to refer to something in my own experience, it would be that it's sometimes surprising how kind of insulated the justices as individuals are from the world.
It's true. It's true. When Alito was talking about, well, if you ride the subway, you need a gun. Someone's going to attack you. Everyone in New York is looking around saying, when's the last time you rode the subway, Alito?
Yeah, well, he rides the subway with a federal marshal, so it's a little bit of a different circumstance if he rides the subway. Yeah, there's a little bit of kind of, they live in a marble palace. They literally work in a marble palace, right? It's like, there's stuff that was specially carved out and imported from Georgia. And so sometimes, they're very alert to sort of the political and the cultural moment that they're in. And then sometimes they're weirdly sort of lagged or tone deaf to that moment. Maybe this is a kind of lagged moment, but it's hard to read tea leaves for a body like the Supreme Court, where we don't get to see the tea leaves. We get to see the dribble of tea at the end of it.
Yeah, and you don't think that just a 9-0 decision, maybe even Alito Thomas? I would think that Gorsuch sometimes gives a ruling that is a brushback pitch to police. They wouldn't say it is so egregious to have certain circuit courts going by moment of threat that the law is clear on this one. It couldn't just be that.
I mean, I would distinguish between Gorsuch on the one hand and Alito and Thomas on the other hand. I think Gorsuch in part because there is this bit of a kind of Western libertarian strain in Gorsuch that's absent in Alito and Thomas. And he is, I think, on policing issues, actually, on Native American issues, really interestingly, he doesn't do what you think he'd do if you were to.
Well, now that you know what he does, he's really consistent on Native American issues. Yeah, that's his jam. Yeah,
he has his hobby horses. So I would just draw a distinction between them. But I absolutely agree with you that it is a bit of a surprise that the Barnes decision is 9-0.
Would you say that every time a right is given, and a right that comes with remedies, somewhere, perhaps abstractly, perhaps not, a right is taken away? What I'm thinking of, Sackett versus EPA. The Sacketts wanted the right to build on that, to build their house, redirecting a river, and the court decided that they had that right because the EPA was overreaching. So, the other way to look at that is the court is taking rights away from the rest of us that the EPA was meant to protect, like clean water.
Yep. I think that an even more direct and powerful example of rights conflict are the cases about anti-discrimination law and religious establishments that serve the public. So, for example, there was a case about a baker who declined to make a cake for a same-sex wedding. There's a website designer who's also who made a claim about a hypothetical plaintiff. No, there wasn't actually a person who was asking her to provide the services in this case.
So this is Masterpiece and what's the
303 Creative VLR.
303. I always get the number wrong. Go ahead.
So those are cases in which there's a very clear conflict between two rights. I think you're absolutely correct to say the super clear rights versus rights cases, like Alanis and Masterpiece, are not the only instances in which there are interests that we can talk about as rights meaningfully on both sides of the ledger. There are absolutely the environmental cases. There was I think a really interesting case a few years ago about the scope of Congress's authority to regulate violence against women. It's a case called Morrison. And you can think about, and the court held that Congress did not have the power to grant women who were subject to sexualized violence, rape, assault, etc., a damages remedy. And that was a case that put, on the one hand, the interests of women in particular who are subject to these forms of predation on one side of the ledger, and on the other side of the ledger was the power of the states to decide on their own rules, and surely the power of, in particular, men to engage in sexual predation, right? That's another interesting and just to flag, right? Maybe we think we're okay with the idea that states ought to have some authority to set their own rules, but we find the idea that men have the right to engage in sexual predation against women loathsome. Like, that certainly would be my intuition. But both of those two things are on one side of the ledger, and then there's something else on the other side of the ledger. So there's all sorts of cases in which there are rights versus rights conflicts, and absolutely. There are some times in which you can usefully characterize the problem or what's at stake as a rights versus rights conflict. I think that there are some instances in which the conflict is described as a rights versus rights problem, but it really isn't. It's
Can all policing, in a way, all policing can be described as, well, my right to safety, and which is not. That's perhaps you would think abusing that idea as a quote unquote.
I was
right.
going to give a different example. I was going to say the case involving same-sex marriage so when that case was argued, it was framed as a rights versus rights problem. It's like, hey, if you give same-sex couples the right to marry, you're devaluing the right of different-sex couples to marry. And there was an argument about kind of stigma and the overflow or the diminishment of the value of marriage. And I think today, I can say, this is my moral view, and I want to be clear, I'm going to take a moral view for just this 1 second. I don't think it is plausible to say that the right that same-sex couples exercise to get married today has in any way devalued the right of different sex couples to get married. I think, on the contrary, the fact that we live in at least a world right now in a country where people of same sex and people of different sex can get married enriches and broadens our sense of what marriage is and creates a bigger space of joy which benefits everybody. So that's a case in which what looked like a rights versus rights conflict turned into something, I think, very different. And it turned out that extending a right made us all better off.
Yes. I do think, and credit, because it was right there and it's something that we all think about, I think that's the easiest example to go for where our changing understanding or experiencing of the morality influences what you said. I think that there are other more recent cases like the Washington State football coach who wanted to give a quick prayer before a game, and then you have a much more legitimate and a legitimate question with equal sides. Yeah.
Absolutely. I wouldn't want to suggest that. Do you want to do policing on the same terms?
Go ahead.
So I think that whether there is a rights versus rights conflict in cases about police violence really depends upon whether or how you think we are made safe by the police, right? If you think that we as a community are made safe by the police by the use of physical force, like the more force the police apply, the safer we are, then there's absolutely a trade-off.
I think come on, that's a straw man. Who really believes the more force, just in general? No one's advocating, no one I know is advocating that.
I think there are judges who say a version of that, but I'm offering you two positions to clarify the thought that you put on the table, which is this a rights? So I think if you think that, then there is a real rights versus rights thing. If on the other hand you think, and there are, I think I'm now going to characterize the position that many criminologists who study this problem empirically would take. They would say, look, the way that you achieve public safety is not through just increasing the amount of police violence. It's through establishing relationships between the police and the communities that they are responsible for keeping safe, that ensure the flow of information, that create trust, and that generate an environment in which public safety is kind of jointly produced by the people and by the police in ways that keep us all safe. Right. This is a theory that is associated with a scholar called Robert Sampson, who was at the University of Chicago, who has a terrific book called Great American City, which is about Chicago. It's a really, really good book about Chicago. If you think that Sampson is right, then the police violence cases, the Fourth Amendment cases involving plaintiffs who say, hey, I've been brutalized by the police, and then they get turned away on qualified immunity grounds, those are not rights conflict cases. Those are cases in which the more that the police are pressed into non-violent forms of social control, the better that social control is. And here's a statistic that always sticks with me. But again, it's going to be a Chicago statistic because this is the place I know the best. In Chicago, only 1 in 4 murders are cleared. Only 1 in 4 in 1 in 4 cases of a murder is a suspect identified by the police and transferred over to the prosecutor's office. And if you look at the accounts, and these journalistic accounts, people are talking to the police, reporters are talking to the police, trying to figure out what's going on with this. The thing that turns out to be the sticking point is people's unwillingness to talk to the police, right? People in Chicago, in the communities where gun violence in particular is concentrated, will not talk to the police. And absolutely, part of that is fear, part of that is gangs, but part of it is distrust of the police. And so if you think that that's the problem, if you think that that's the friction that's preventing us from having a safer city, gosh, it's really hard to say, well, if you increase the amount of force that police can use, you're going to make that problem better. And you might even think about the constitutional rule that's embedded in the Fourth Amendment against unreasonable forms of state violence. You might even think about that as a kind of guarantee. It's like, if the police can credibly say, hey, we're going to stick to this Fourth Amendment rule, that builds a kind of trust with the communities they're in. And maybe that's a rule that makes us safer, right? So a lot depends, in thinking about rights conflicts, in how you think things fit together and the story you tell about how the goods that we value as a community, as a people, like public order. Everyone values public order. Nobody's out there saying, hey, we ought to be like the Purge Day, whatever that day is, right? You got to tell a story about that. And depending on the story you tell, maybe there's a rights conflict and maybe there's not.
I'm glad we took it here. By the way, have you seen the recent statistics from the Chicago PD on clearance rates for homicide?
You're going to tell me?
I knew it was high because I know that we're setting records everywhere for low homicide rates. They claim it's 87%.
They claim they're clearing, or they claim they're...
Yeah, I'll read it to you. Hold on. And I know New York has always been higher.
New York's
Baltimore's always been
New
low.
York's very different.
I'll read it to you. Chicago Police Department, January 25 in review through January, the homicide clearance rate is 87%, which is 52% higher than this time last year. Wow.
Okay. Wow. 52%. That's interesting.
Yeah. And New York they have a 50% clearance rate on murder and on felonious assault.
Chicago for a long time was the lowest in the country, and absolutely there were many places, including New York, which had much higher. I think it's places like Denver and Phoenix have a number that's constantly been in the 70s or 80s for a long time.
Yeah.
So there's a lot of
Baltimore's very
variance
low,
between
too.
different places.
Correct.
But I was giving the example which was at least historically true until last year.
Oh, that is true. So while I have you here, there are two more things I want to do. One is to ask you in general about your really great other thesis that you wrote about, I think, in Politico, about the dual nature of the legal system. But I do want to ask you about, just thought came up to me, Grants Pass, which was the recent Supreme Court ruling that essentially did away with an old ruling that the Ninth Circuit followed, which is you can't criminalize homelessness. What the Supreme Court just ruled on exact ideological lines is not that you can, but the municipalities that were arresting people for public camping were doing just that. It wasn't a status that they were discriminating against. It was an action. And so I'll put my cards on the table. I'm very sympathetic to the homeless, and yet at the same time, I guess I want the state to have tools at its disposal to clear homeless encampments from time to time. I agreed with the 6 part of that 6-3 ruling. My question for you is, you tell me if you agreed or disagreed, but can you assess, it seems a very, very hard ruling to pick apart by just what the law says. It seems to me like a competing virtues claim, and there's good, robust arguments that the municipalities were illegalizing an action. But there's also, like Sotomayor wrote, a good, robust legal framework to say it's criminalizing a status. How do you look at that?
I think that the decision rests upon a distinction that looks like it is obvious to apply, but turns out to be profoundly moralized. Here's the distinction. The distinction is between status and conduct, right? And you've already referred to it. But that distinction comes out of an old case. I believe it's called Robinson, although I might be getting that wrong, which says, look, the state can't come along and say, hey, you're a drug user, therefore we're going to lock you up. Because drug users is a status, and you can't help being in that status. You know, what the state can punish you for is the things that you choose to do. And so the status conduct distinction is drawing upon a really powerful moral intuition that is key to what I would call the small L liberal tradition, that, look, you can be punished for the things you choose to do, but you can't be punished for the things that you are, right? Status versus conduct. Turns out, however, that distinction is really, really hard to draw in the real world, because the things that you do are profoundly affected. They emerge sort of almost directly out of the things that you are. And so for a lot of human behavior, drawing this line between the things that you are and the things that you do, between status and conduct, is really hard and requires not a judgment about the facts, but a judgment about morally what we can be held responsible for. So, for example, let me take the most sympathetic case to the dissent here, right? So if you have a family, right, or let's say you have make it even easier, somebody who's underage, who's run away from home, who's on the streets of the city of Grants Pass, right? Let's say they've run away because they're subject to physical violence in the home, which is very, very common. And they're living, under a bridge in Grants Pass. And the city comes along and says, well, look, you've decided to live under the bridge, and you're therefore responsible for your behavior. That's the position that the court accepts. The person can, I think, without sounding facetious or sounding, dishonest, say, hey, no, this is not something I chose, if you mean choose in any meaningful sense of that word, right? Yeah, absolutely. I ran away from home. I am under this bridge by, in some sense, an act of my own volition. But it violates the English language. It violates our moral intuitions about the way we use words to say, this is a situation of my choosing. Mm-hmm. So I think what's going on in a case like Grants Pass is that you actually have this profoundly I don't even think it's a question that the law answers. I think it's a question that is deeply, you can't answer it without reaching within yourself and asking, what are my moral intuitions about when and how people make choices? And that's what's playing out between the majority and the dissent in that case. And I think if you're reading that case, part of what is hard for law students, for example, and it's a case that I teach in property because I think it's a really interesting case that tells us something about how we relate as human beings to property. I think it's a case that where the real issue, which is this moral question of how do we think about choice, just isn't there on the surface of the case. You have to really push hard into the case before you see that is the real dividing point between the majority and the dissent.
Yeah, that's interesting, especially if the law school has a colloquium with the ethics department. But the Supreme Court...
No, we don't do ethics. We're the University of Chicago. I'm kidding.
But the Supreme Court is not charged with deciding the morality. It is charged with deciding the law. I'm sorry to be so blunt with you. So where would Sotomayor and the other two liberals find... Yes, I understand. There is the question of status.
It's a problem on both sides, and
So what would be the problem for the majority saying that
on either side you have to say this is status or this is conduct?
Yeah.
And in drawing that distinction, you have to appeal to some kind of a moral notion, and I'd push it a little.
But sorry to interrupt. I think that if it's so hard, you have to default to we as the Supreme Court have to. If it's so hard, we have to throw up our hands and say there is no clear moral answer to this. So therefore, we defer to what the law is, what the established law has been.
I think that there are many questions of particularly constitutional law which it is impossible to answer without appealing to some kind of moralized notion. I think that that's true, for example, of the phrase free speech. It's impossible to know what's free speech and what's not free speech without making some essentially moral judgment. The Constitution uses the words equal protection, but it doesn't tell us what kind of equality that entails. It doesn't use, for example, the words equal protection off the races, which is something that was in earlier drafts, right? And therefore, it requires a moral judgment. So at least the way we have written our Constitution, the gap between law and morality is not one that can be sliced neatly. Now, one of the things I spend my time doing is thinking about how other places write their constitutions and organize their law. And it turns out that there are other constitutions which don't draw upon moral distinctions. They just avoid using language and using concepts that require moral thinking. And they're different in that regard from the US. And there are also places where, and Canada actually is a kind of interesting example of this, as is the United Kingdom, in which, they have concepts in their constitutional order that have a moral complexion to them that can't be seriously thought through by bringing to bear some kind of moral thinking. But they don't reserve those decisions to judges. In Canada, for example, judges decide constitutional cases under what's called the Charter, but those decisions can be overridden by a legislature. In the United Kingdom, they don't even have a written constitution. And even when there are fundamental rights cases under a statute called the Human Rights Act, those decisions can be overridden by Parliament. And I think that those systems, which are common in the world, they're not. It's not. I gave Canada and the UK as examples because they're sort of close in some ways. Those kind of systems are a recognition that law, especially basic law, will often involve profoundly moral decisions. And maybe we shouldn't give those decisions to judges. Maybe we should give them to people who are directly elected and therefore have some sort of democratic license to engage and think through moral questions. And to my mind, this is one of the profound questions in the design of constitutions, right? Who do you give the power to decide these basic moral questions to? Do you give it to judges, or do you give it to legislatures? Do you give it to the people through referendum systems? And you look around the world, and places do different things, right? There are lots of different ways of doing it, and if you look at the places, some of them will look. So, for example, in Sweden, I was just in Sweden for an academic conference, and I was we're talking about this very question. And it turns out in Sweden, there's a constitution. It's full of moralized terms. But courts are just like, no, we have no role in reading the constitution. We just don't do it. We just apply the statutes. We don't even look at the constitution. And they thought, I was talking to an academic, and he said, well, look, it would be crazy for judges to read the constitution precisely on the grounds that Michael, you were just saying, because that would undermine the motive for legislatures to engage in serious moral deliberation. So the judges are going to hold their fire so as to make sure that the legislators take their job really seriously, and that's just the conventional wisdom. That's just the way the world is organized in their legal system, right? So there's super different ways of doing this and organizing this. And I just to be clear, I'm not saying that one is right or wrong. I'm just saying, hey, look around the world, really different ways of doing this. Don't take for granted that our way is the right way.
I have to ask you two more things about Grants Pass. Yes, of course, morality informs and is shot through the Constitution, so there are always moral components to reasoning. Do you think when the justices engage, how present or front of the mind is that? Do you think that the justices arguing and deciding on Grants Pass were saying, what I am doing now is essentially a proxy for my morality? Or are they saying to themselves, what is the law? Let us apply the law. Let us apply precedent.
I don't know what's going on in the head of different justices. I think that the person I worked for was always alive to two possibilities. The first is that there can be a body of law. The body of law can be clear, and it can direct something. And then you do the thing that the law directs. Or you have a law that is, in some sense, open on the surface, and so allows for the consideration of moral questions. And provided you are candid about where and how you bring to bear the moral reasoning, you're still doing law. Right, provided you're not hiding it, provided you're not being deceptive about it, you're still doing what in the American, maybe not the Swedish, but in the American tradition is recognized as law. And that's perfectly acceptable. So I think that the thoughtful judges, and I can only speak to the person, I don't know what other people do. I don't know how they think about it in chambers. I don't know how they talk to their clerks about it. But at least in my experience, it is feasible for judges to think about that. And I just add one thing to that, which is, I clerked for a judge who was very liberal, but who happened to be very good friends with a judge who was very conservative.
We could name these Ruth Bader Ginsburg and Antonin Scalia.
Yeah. They were good friends. And I got to know a lot of the Scalia clerks very well. And I would say that the same was true in his chambers as was true in Ginsburg's chambers. So I don't, what I'm saying, I don't think has it's not about being liberal or being conservative. You can be a good judge, faithful to the law, recognize when the law leave space for some sort of moral reasoning, and be kind of candid and clear about what that moral reasoning is.
Yeah.
And be both honest that you're doing it and honest about the quality of it. And I think for better and for worse, both Ginsburg and Scalia did that. I think it made their opinions, in a sense, more transparent than maybe what's the case for others. And I don't think there's anything illicit about that.
Last question, and I can't get into the Atlantic piece, The Dual State. You've been very generous with your time. I'll just recommend that people read it. It's really interesting. In this Grants Pass case, given that we've talked about the morass of trying to sort through the morality and the close calls about morality on either side, and we've also acknowledged that this is how judges reason and morality is a part of their reasoning. I would think, if I was a justice on the Supreme Court, I might find the morality so hard to get a clear answer for, and so at best a 51-49% determination, that I would default to the public policy. The public policy questions are things like, well, if you don't let the police clear these areas, they often fester and are dangerous for the residents, and diseases spread, and all the public policy implications. If you do, there's also public policy considerations in that way. What are you doing with the rest of the homeless people? But judges aren't supposed to do that too. To me, using a public policy lens on this question, essentially becoming a legislator, is much clearer than using the philosopher/ethicist lens. So I would grasp for that. Are you not allowed to do that?
I think that the direction that you're pushing in is the direction that was taken by one of the greatest justices in American history, a man called Oliver Wendell Holmes. And Holmes was first a Massachusetts judge, and then he becomes a justice of the Supreme Court. He very famously dissents in a series of cases concerning liberty of contract. And it's often taken that his dissents are about his disfavor of libertarian views of regulation. But that's not actually what they're about. It's not what he says they're about. What he says is rather a version of what, Michael, you just said. He said, look, it's not my job to make moral judgments. And it's also not my job to make public policy judgments about how many hours a person can work or what a minimum wage ought to be. Because
those are New York bakers, right?
Exactly. Those policy judgments, kind of along the lines of what you were saying, were basically judgments about what's morally right and how we should organize our society. And I don't do those either. And my job is just to make sure that the trains run, in terms of our political system, the trains of our political system run on the right tracks, and everyone knows when the train's coming and when to get on, and that's it. I'm just the signal person. I'm just making sure everything is working smoothly. My job is not to tell you where the train is going. My job is not to tell you when and how the switches get pulled. It's just to make sure that they're there and that they're pulled when they're supposed to be. And if, said Holmes, the people acting in a majority want to take the train to hell, then it is my job just to help them do that, just so long as they're doing it by the ordinary rules that the law provides. So Holmes's view, I think, it's a really powerful view, because I think it picks up on the intuitions that you've rightly put on the table. But I think for many people, that the sort of I'm happy to let everything go to hell because it's not my problem. There's lots of people who have a lot of hesitation before embracing that point of view. So absolutely, the argument that you've given, I think, is a really powerful one. I think it drives us to the position of Oliver Wendell Holmes, and that's not a bad position to be in. Like, one of the greatest justices of all time, right? But it's also a position that many people are profoundly uncomfortable with.
Yeah.
But I think if you can
great facial hair, knew about the F train. Speaking of the train to hell, I can only assume that's what he meant.
Yes.
Aziz Huq is the author of The Collapse of Constitutional Remedies. I've also been promoting his recent Atlantic piece, America is Watching the Rise of a Dual State. He is a professor at the University of Chicago School of Law. Thank you so much for joining me today.
Thanks very much for the really smart questions and terrific conversation, Michael.